Okay, hi everyone. It looks like folks are coming on into our Zoom room. Thank you all so much for coming today. This is absolutely wonderful. It's a brilliant turnout. We're also lucky to have you all here and to have our illustrious panelists here today. It's truly my pleasure to welcome you to this fantastic event on teaching international trade law. My name is Joanna Langille, and I'm an assistant professor at the University of Western Ontario Faculty of Law. And I'm also the co-chair of the American Society of International Law's International Economic Law Interest Group, who is organizing this event today. And our event today is a roundtable discussion featuring four luminaries in the world of international trade who truly need no introduction. I think their work should be familiar to everyone here today. We have Petros Mavroidis of Columbia University. This is in no particular order, just as I thought of people. Chantal Thomas of Cornell, Jennifer Hillman of Georgetown, and Julian Arato of Michigan. And Julian was also instrumental in helping think of this event and put it together. So thanks so much to Julian and to our other amazing co-panelists today. So the purpose of our event today is just what it says on the tin. We're going to reflect on how to teach international trade law. And I think for those of us in the field, trade has always been a challenging class to teach. This is a field that requires substantial knowledge of background history, politics, economics, development economics. The legal materials themselves are lengthy and sometimes difficult to follow. And the field is intimately related to other legal areas such as investment law, IP, domestic tax and regulation, private law, for me, private international law, and the list kind of goes on and on. It can be hard to disentangle. But I think for those of us in the field, teaching trade law has become more complicated or even more complicated recently. As we all are aware, recent political events have radically destabilized the World Trade Organization as a legal order, including the destruction of the dispute settlement process. And certain countries, I'm not going to name any names today, but certain countries have begun to flagrantly violate the rules of international trade law, challenging what we might think of as the rule of law in the field. And so I think this is a really interesting moment to think about how to teach a legal class on an area of law that is very much in flux from the perspective of legality. So we've therefore brought our speakers together today to reflect on that new legal reality and how to teach in that context. We're going to today hold what I hope will be a very informal roundtable. I'm going to throw some questions at our speakers and maybe suggest that one person kick off the conversation, and then others are going to jump in as they see fit. This is not all prepared in advance. We really are thinking through all of this with you here today. So we're very excited to have this conversation. I'm going to moderate as needed and maybe ask some follow-up questions. And of course, there is the Q&A function for all of you in the audience today. So feel free to put your questions in that Q&A. I'll try and integrate those questions maybe in the conversation. And perhaps if we have a few minutes at the end, I can also ask some of those questions there if we don't get to them. Although we'll just see, this is the excitement of the roundtable discussion. We don't know what's going to happen, and we're going to kind of let things flow naturally. So thanks to everyone for being here today. This is such a real pleasure for me. And so without any further ado, I'm just going to get us started on our conversation. So I want to start with a very broad question about teaching international trade law, which is, do you have a theory of what goes into an international trade law class? I know in Julian's class syllabus, which I've taken a look at everybody's syllabi here today, Julian uses Julian's first session is on the telos of the WTO. And so I think he has a theory perhaps of how to organize the class, maybe on that basis. But I want to maybe start with you, Petros. Do you have a theory of what must be taught in an international trade law class? What's in, what's out, what's the theory of how you animate it? And thank you so much for being here. Oh, and you're muted. And I don't know if I have the power to demute you. Let me see here.
I'm demuted now.
There we are. Brilliant. Thank you.
Thanks so much for hosting me. And I don't know if I have a theory. I have an approach. I mean, I do four things recently. I changed a little bit over the years. I always start from economic history because to my sense, students should know that what the GATT is coming from and what was the idea behind the GATT. And they also need to know, in my view, the property rights of the GATT, because this was written by specific people who had specific ideas coming from specific legal contexts. So to me, the first part is very, very important, the economic history of the GATT, and this is where I discuss the GATT thing. The second part is what you would call the legal part, the WTO contract per se. And there, what I try to do is teach the contract through case law, but also add a lot about practice, because some practice you'll never find it in, let's say, WTO disputes, but you will find it in WTO committees. Voluntary import expansion has never been litigated, but it was a very prevalent instrument in the 80s and the early 90s. The third part is I shift gears and I discuss FTAs because, in my view, in today's world, no, forget today's world. Heterogeneity of membership and deepening of commitments is a zero-sum game. So you cannot go very far through the WTO with 166. And this is why we observe FTAs and the WTO plus extra obligations. So I take 5 representative FTAs and I go through them. And finally, I discuss the institutional design. And I try to make students aware of the differences when I do dispute adjudication, if there are any, how they're explained, let's say at the WTO level and at the USMACA level, or the EU Mercosur agreements and so on. Voila.
Brilliant. Anyone else want to jump in, or I can start calling on folks as well?
Well, I'll not disagree with anything Petros has said, but I do think there's a couple of other things that I always think you need to emphasize when you teach. Trade law is part of it is to understand the relationships between the trade law and what governments do, as opposed to what the private actors that are the traders need to do or are doing. And so I always try to make sure all my students understand, again, that trade law in the sense of the WTO agreements or free trade agreements are government to government agreements that nonetheless have an effect on private behavior, and important to understand how is that link between those government to government agreements versus the private behavior. And the second part I think that I would add to what Petros has said is all of this law that is developed under a free trade agreement or under the WTO has to then come into the domestic law of the country in which you're teaching from. So for me, I do always spend a little bit of time trying to make sure students understand how did the Uruguay round agreements become law in the United States? How does the USMCA become law in the United States, and what is that process itself, and where is trade law codified into the US statute books, and where is it not? I mean, where is it still left out there as a function of international law? Because I do think those are other aspects that students need to understand about how trade law actually functions.
That's great. So a strong kind of foreign affairs and the constitutional was part of your class, Jennifer. That's really interesting. Anyone else want to come in on that?
Yeah, I can jump in on that note. And first of all, thank you, Joe, and thanks to the organizers for this session. It's actually really helpful to me. I was saying to Joe, I'm teaching international trade law this spring, and I'm really wondering how I'm going to present the material because, to Jennifer's point, the domestic legal frame is certainly, it's always been relevant in teaching international trade law in the US, but it's much more relevant now because of the aggressive unilateralism, to rehabilitate an old phrase, that we're seeing in the US. And so domestic statutes are much more salient even than they have been previously. So I plan to probably spend much more time looking at the 1930 statute, the 1974 statute, and the sort of number soup, 201, 301, 232, and the like, sort of trade remedies and processes. But I guess just in terms of teaching and sort of the theory, I also think about outcomes and what I want students to come away with. So one dimension of it is actually from a careers standpoint. I think for a lot of students who are interested in international law, sometimes they're not sure where the path is to go into practice if they're interested. And I try to make that clear. In part, that's why I try to invite guest speakers who are both in the international organization side, the domestic US side, the civil society or think tank world, and kind of get a sense of what kinds of careers are out there. And so that's one reason to highlight different dimensions. But also, I think of it as a mix between wanting to develop a proficiency in the Black letter law and also kind of broader understanding of the underlying debates. So another outcome is just proficiency in, picking up a newspaper, if anybody picks up physical newspapers anymore, or look at the news and being able to understand and decode the debates when students leave the class.
That's wonderful. Julian, a final word on that, or?
Yeah, I mean, my overarching philosophy in a course like this, I mean, I teach a 4 credit trade course, so it's a pretty big one. And still, my philosophy is at the end of the day to do less, as little as possible, but as deeply as possible. Because I get stressed out by thinking about the wide variety of things that one would have to cover in a course like this. But also, at the end of the day, I feel that I can only give the students the ability to answer these questions for themselves. So to that end, I think I'm very much aligned with what Chantal said about what are the professional and intellectual goals of a course like this. And to me, the professional goal would be I want to teach the students how to competently litigate a case at the WTO or in an FTA. How many of my students are going to go do that? It's very few. Right. Very few. I mean, now next to none. Right. But very few, even in the past. But the point of teaching a course oriented towards the ability to accomplish that type of work is not about, this is going to be your career and you're going to go do that. It's about helping to understand the fundamental tenets of the system and how you would work with them. And there's a lot of transferable skills to other areas of law from that. So just what I would say I stress the most in my course is how to deeply read treaty text, how to deeply read a case, and above all, how to work with facts, how to drive home a legal argument, how to do better than the lawyers in the actual case and make your own arguments using the facts of the case and seeing how the law can't encounter facts without adaptation. It's not that dissimilar from how one would approach a contracts class or something like that, except for the intense complications that this field of ours adds.
Fantastic. Yeah, whenever I teach a legal class, I tell my students, I'm not teaching you the law today. I'm teaching you basic structure, basic principles so that you have the capacity to learn the law as it evolves in the future, because by the time I'm finished this class, the law is going to have changed. So in some ways, I think a lot of us try and there's a sort of future proofing that we can do by focusing on basic structures that maybe some of us are even doing in classes like contract or tort or what have you. But still, I do think, and this brings me to my next question, I do think we're in a unique moment in terms of teaching this class in particular. So I want to now open it up to the floor, perhaps beginning with Chantal. Are you reacting to the current political moment at all? Has the aggressive unilateralism changed what you're thinking about in terms of your teaching your trade law class? What about the death of the dispute settlement process? Or perhaps that's too early to say. I'm really hoping that's the case. But how is your approach changing, if at all? And I guess I'll start with you, as I say, Chantal. Thank you.
Yeah, thank you. And I'm really curious to know what everybody thinks about this question. I mean, as I was suggesting earlier, I think I will make definitely some adjustments in terms of the materials. I mean, IEPA, for example, is, a statute that had not been studied in previous iterations of the international trade law class that we'll spend some time with now, because it is providing the frame for the current, the new sort of tariff regime at the moment. But I always try to situate at the very beginning the class within a broader understanding of, again, the sort of underlying debates in international trade law. And in that sense, I think it is fair to say that although in some ways this is an unprecedented departure and kind of we're in a sui generis moment, in other ways we can certainly see continuities here in terms of the challenges that have always been present as far back as we want to go in studying the international trading system to the international trading order, from domestic protection, from the desire for sovereignty and domestic policy space, those themes are not new. They've sort of reared their heads in, a very striking way now. But so to that end, I always start out with a kind of a double axis. I adapted from John Jackson's power-oriented versus rule-oriented, but I think about the trading system on a spectrum from institutionally from pragmatism to legalism, and substantively from protection to liberalization. And if you look at that axis, you can situate different moments over the past century or so of international trade in kind of different quadrants. So in the interwar period, we could say that it's a time of, obviously high protection substantively and very little institutionalization. The GATT, you're moving on this sort of trajectory towards more institutionalization, but still with a lot of exceptions, a lot of flexibilities. So kind of in a middle point, substantively and institutionally, and the WTO is moving further up to the top right-hand quadrant, but it allows you to see the possibilities for movement, in kind of backlash or reaction. And within that larger trajectory, you can see there are moments where there are sort of struggles or kind of dotted lines in the double axis. So the last period of quote unquote new protectionism in the 1970s and 1980s after the Tokyo round had substantially advanced the level of liberalization and institutionalization. You saw a rise in what were called voluntary restraint agreements before they were outlawed in the Uruguay round, and an increase in the use of trade remedies. That was a backlash at that point in time. So when you look at this kind of broader historical trajectory, it allows you to see that, as we were moving in this direction, there was always going to be the possibility for reaction, sort of point and counterpoint. So I think about 20 years ago or so when I was first starting to teach international trade law, those early classes where we pondered, like, could there be a backlash as we move in the direction of greater legalization and liberalization? I wonder if my trade students ever reflect on those debates. But so the bigger point is, I think the historical understanding, to go back to Petros's point at the beginning of the conversation, really allows you to see the current moment in context, even though in many ways it is also unprecedented.
Yeah, that's great. I think something many of us are struggling with is this a moment like those other times in history when we've seen a rise in protections? Are we in the 70s, right? Or are we in something else? And I think that might be affecting how we're thinking both about the field and its practice in general, and also our teaching. Anyone else want to come in on this kind of the central question of our conversation today? Petros,
Sure.
I see you. Or Julian. Yes, Julian, go to
Sure.
Tom. Thank you.
Yeah, so I mean, my course really focuses on the WTO and specifically case law. And, that's not because it's all unproblematically chugging along, right? I mean, the Appellate Body is not doing case law. It's not doing anything right now. Maybe it will come back one day, maybe not. WTO is, it's in dire straits. But, I've been doing a lot of soul searching about the question of whether that requires or promotes different sorts of questions that we should be studying in a class like this. And for now, at least, I think there's a real justification for continuing to focus on the WTO context. And that's because the WTO appellate body's jurisprudence, the jurisprudence of the panels, gives us a pretty unique, robust, and sustained judicial encounter with the core disciplines of international trade law. And those core disciplines are still the core in FTA after FTA. You see it everywhere, but you don't get that kind of jurisprudence. So we could say, oh, the WTO is not doing much, and so now let's just study FTAs. Well, what are you going to do? Read the text and just sit there and do a mind map of Article 3 on discrimination and figure out where the problems are going to be? We'll do the mind map in the WTO context, but then we'll look at some cases and see how they're analyzed. You could do this with the EU, I suppose, but it just doesn't feel like international trade law in the same way. It's too robust of a system in the EU. So I think it's still justifiable to do this through the WTO, as long as you're not pretending to your students that everything is business as usual in that context. It's an intellectual set of tools that we're giving to the students to learn trade law through what is still the crown jewel of international trade law, even if it's maybe in the freezer right now. That said, I've moved to do more on the US. At the moment calls for it. It would be, I think, irresponsible, not just in terms of information that we're conveying to our students, but in terms of meeting the political moment, to not equip students in a trade law class to grapple with questions about the US's role in the trading system. So personally, the way that I've made this switch is first, within the WTO, I've focused much more than I ever used to on trade remedies, the kinds of things which the US government has had really strong views about in international trade, litigated those views at the WTO, and arguably its very negative posture towards the appellate body system is based on the trade remedies fights that they've had. And I sort of transitioned that into thinking about other ways that the US has all along promoted a little bit of a unilateral option for itself in various ways: dispute resolution, national security, and then move from there at the end to analyze the return of tariffs in the Trump system. I don't spend a ton of time on that because, first of all, it's all a moving target, and second of all, the legal questions aren't that hard. They're just violations of the law, but we do have to still talk about what that all means for our discipline. And so I do want to spend some time at the end doing that.
That's great, Julian. Thank you. I mean, I suppose one reaction I have to that is, okay, we need to continue to learn about the law of the WTO because it's going to apply in FTAs. But one thing we've seen in the FTA landscape is a very different account of dispute settlement, right? The rise of, or the increasing rise, or however we want to describe it, of much more political approaches, much less legal on the axis that Chantal gave us at the beginning. And so I guess maybe I want to even push this point a little bit further. Are we still teaching an area of law, I suppose, if I want to put it so bluntly? Are we really just talking about an area where the rules are observed in the breach? I mean, I know we're seeing statistics that the WTO is saying that still trade is largely governed by MFN. We're not seeing a huge deflection away. Perhaps that's the response. But maybe we want to think about whether this is law at all anymore. So that's a very provocative way of asking the same question. And you don't have to answer that. Perhaps Jennifer or Petros, you want to.
Well, I was only going to piggyback a little bit on what Julian was saying, because again, for me, and basically both what Chantal and Julian were saying is, for me, yeah, I've changed sort of how I approach some of the teaching in some ways, and in other ways I have not. I mean, I would say, like Julian, I still think there is real merit in teaching some of the WTO cases, because they are our way of really grappling with what does, national treatment actually mean? What does most favored nation actually mean? What does saying there shall be no, quotas, et cetera, what does that actually mean? What do the exceptions actually mean? Because most of that language is also practically word for word in every free trade agreement. As is the process. I mean, the panel process as it was set up at the WTO procedurally is very, very close to the procedures, at least that I'm aware of, in the CPTPP and the USMCA and in many of the other major trade agreements. So and many of, again, the CPTPP very directly says, if you're a panelist for a CPTPP case, what are you supposed to rely on? The jurisprudence of the WTO. So for me, on the one hand, there's really important continuity to stay with making sure your students understand that jurisprudence and that it remains significant. Again, in many contexts for them to be able to understand. And at the same time, I think you have to be very clear about some of the differences in the way that you teach. I mean, I used to teach my opening lecture sort of why do we trade at all, and dive into Ricardian theory of comparative advantage. Well, there is where you really see very significant changes, where I've been very lucky to have been part of a textbook that pulled from a lot of what Nicholas Lamp and Anthea Roberts did in their book 6 Phases of Globalization, to really help students think about the various different narratives that inform kind of where we've ended up, why there is this pushback, blowback to some of what was happening in the trading regime, where I do think you need to be honest about teaching differently about how the world, if you will, is thinking about it. And obviously, to me, the third area, I mean, having authored a textbook in in 2017, in which the entire discussion about national security and Article 21 of the GATT was a single footnote that basically said it's never been used. It's there, but it's of no moment. To an era now in which almost everything that's happening in the trade space is coming, or at least has somewhat of a lens of national security and sovereignty in a way that didn't used to exist. My sense is everyone has to pivot to understand, how does one think about bringing in that national security context into what you're teaching about trade, because it is going to color an awful lot of whether certain things are considered legal or not. And again, to me, the exceptions to the rule end up becoming really, really important for students to understand the boundaries of those limits and to, go in way more detail, deep dive into both Article 20 and the general exceptions to the GATT, and Article 21, the national security exception to the GATT, which is, again, something pretty new and different for those of us that have been teaching this for a while.
Petros.
So, I want to repeat everything I like. I also believe in one sentence that what happens nowadays is a complement, not a substitute for teaching WTO. So I don't know if you looked my teaching schedule. I have added stuff in the fourth part, and I do two things which have not been mentioned. The first is I go back to Kindleberger explaining his anger with the US policies in 1929 and why the leader has to invest in a regime. And I try to make students understand what was pushing Kindleberger to bring up the hegemonic stability theory. I was never into the argument of Cohen and Schneidel. I don't believe their argument. And what is different nowadays. And I use the work of Manuel Ornelas. This is an economist from Stanford, first, now back to Brazil. Why is it very difficult to put Humpty Dumpty back together again when you have three players who are very heterogeneous? So this is the first part. And the second part, when I look into FTAs, because I teach, as I told you, the third part of my teaching is FTAs. When I look into FTAs and WTO, I observe two things myself. The first is there is no forum deviation with respect to adjudication. There are very, very few disputes before FTAs. And the second is there is a huge forum diversion with respect to legislation. If you look at any agreement in the last, what the World Bank calls deep trade agreements, and you look at just the table of contents, forget the rest. It is two ships passing by in the night, this table of contents in the WTO. So I ask students, and I ask myself still, because I don't have a ready-made response either, and that's an area where I work with my permanent co-author Henrik Horn, a Swedish economist. Why do we observe legislative deviation and not forum deviation with respect to adjudication? Is it because the contract is more complete in FTAs, hence you reduce the probability to have disputes? Is it because players are like-minded? Is it both? And so on and so forth. So this is how I try to bring the discussion up to speed, because I don't know if Trump is a parenthesis or not a parenthesis, but the world we are about to live in the next years, I think, we can never predict the future, is a world where you have and Trump and the WTO and the FTAs.
Can I just say one quick thing to respond to Joe's provocation about the FTAs and dispute resolution, which I think is a serious one. I mean, I agree with Jennifer and Petros that if you look at the big marquee FTAs, there is real dispute resolution. There's always these footnotes about kind of piggybacking on appellate body jurisprudence. There's a lot of interesting linkages in there, but some of them, the dispute resolution system is more awkward. I mean, USMCA is a good example of that. I know Joe's interested in, and we can't rest on our laurels. If the WTO goes south completely, one could imagine FTAs, having less robust dispute resolution in the future. So let's imagine a world where we don't have any dispute resolution system in trade at all. I just want to say, I don't think that means it's non-law. I don't think that means that trade law is not law. I mean, I'm first and foremost a public international lawyer. I better not have that view, right? We have lots of really, really important international law where there's no judicial institutions whatsoever. And a lot of it works, not all of it. Some of it works poorly, some of it works well. I think we would lose something major in terms of the rule of law at the international level if we didn't have robust dispute resolution for trade, for sure. But do I think that it would be a world in which national treatment and MFN don't or can't mean anything, in which general exceptions don't mean anything. No, those things could work and to an important extent and in important ways. It would just look very different than what we have now. But they're still worth teaching the norms.
I think that's great. Julian and I were in the same public international law and international trade law class with Joseph Weiler, and Weiler always said, we never at the domestic level say the fact that murders take place means that there's no domestic criminal law. And I think that those of us who care about international trade law may need to take a similar approach, which is to say the fact that rules are violated doesn't mean there isn't law. And I think the new data coming out about obviously compliance has a role, but it's not what defines a legal order, I think we might say. And so, and I think the compliance stuff is actually looking pretty good. So to answer my own question, I'm actually not that concerned, but I think one might be. So that's great. Well, the next kind of area I wanted to talk about was something we've now already touched on. I wanted to ask, and I was going to start with Jennifer because she's in kind of a privileged position among members of this the group. I was going to ask about the value in still teaching WTO cases, if there is any such value, now that obviously the appellate body isn't producing any more decisions. And I think we see now, it looks like dispute settlement filings are slowing down, even in the presence of the MPIA. I think people are starting to not file to the same extent, as I understand it. I think you touched on this, Jennifer, so perhaps you don't have anything else to add, but what are we going to do with these legal materials? Is it going to be like, I don't know, the Old Testament and the New Testament, like we have these old materials and now they're kind of hermetically sealed and we can refer to them for our new disputes or something like that? But I kind of wonder about the status of these. I've been reading a lot of Aquinas, Julian, sorry. But yeah, I think we have a real question, right, about the legal status of these materials and obviously how we're going to relate to them in class, but also otherwise. We know we've all talked just now about how these are live legal materials, even if they're not live in terms of new disputes, because FTAs refer regularly to this jurisprudence. FTAs often simply incorporate GATT provisions and other WTO disciplines wholesale, right? That's kind of what they do. So it's clear they aren't going to go away altogether, but how should we treat them in a class and perhaps otherwise? And Jennifer, I don't know if you have anything to add there.
So again, as I said, I think they are important in part because, again, they are ways of understanding what do particular words mean. And those words are going to live on and on and on, even if the dispute settlement system doesn't live on. So if countries want to understand what their obligations are, you need to understand what those particular words mean. And I think the way that you can at least try to understand what they mean is by looking at the cases. Now, you may decide that you don't agree with the case, or the case may become outdated or overtaken by other events, but you at least have that. So again, for me, I think it still remains relevant. And like I said, I think many of there will be, I think, continue to be at least some disputes under the free trade agreements. And those are going to also continue to rely on that jurisprudence. So I do think the cases are worth teaching. They also have, again, a lot of the cases, they have really interesting facts and they're posing these very difficult to decide questions. If you were sitting there at the appellate body, would you have decided it this way or that way? It's a way of really, I think they can be very engaging for students. To really put them in the position of, okay, let's just say you're litigating this case. What are you arguing? What are you arguing about? What this means? Why? Et cetera. So I also think they are good at helping students think about, again, how to form an argument. And then you can kind of see it, how it played out in the briefs that were actually filed or in other parts of a case. But to me, they are helping students think like a lawyer. About how to approach a rule of law. It could be in any context, but I think the jurisprudence of the panels and maybe some of the appellate body is illuminating in terms of how do lawyers grapple with these problems in a way that you can make it kind of fun to have students kind of relitigate some of the key cases. I think it can be a very fun way to teach. And again, helpful across the board for students just learning to be a lawyer.
Yeah, I guess I'll jump in and just agree, wholeheartedly with what Jennifer and Julian and Petros have said. There's no question that from an interpretative standpoint, as Jennifer was just setting out, that the normative framework has been profoundly informed by the last couple of decades of WTO jurisprudence, and that sociologically, the replicating of the key norms in the much larger framework of regional and preferential trade agreements also speaks to their sort of organizing power as normative principles. So I think both the initial agreements and the jurisprudence interpreting them will continue to have an effect, regardless of whether what happens with the appellate body and the MPIA. But I mean, interestingly, the WTO dispute settlement system is still working out really interesting problems, like the recent decision on the EU Indonesia, looking at the question of third country subsidies. I mean, that's a really interesting fact pattern. What, in this case, if China's investing in another country, can that other country be subject to countervailing duties? And the panel sort of worked out that question. That's really interesting. The fishery subsidies agreement is really looking at an area and a kind of trade and area, so trade and the environment, and sort of speaking to, I think, a really important aspect of that emerging area of policy. So I think there's a lot of value still in focusing on the underlying framework, but I always think about supplementing as well. I mean, with free trade agreements and the USMCA, I think the rise of the rapid response mechanism in its approach to labor in a really distinctive way that I think turns the page and kind of a new era of trade and labor policy. So it's both, the fundamentals and also, updating with contemporary challenges.
That's excellent. I think the idea of making explicit why we're referring to these materials is also important for us as teachers, right?
Yeah.
So you might say, we're going to explain why this system isn't functioning anymore. Look what's happened. But also we want to explain why these interpretive texts remain so vital. And so I think kind of closing that loop is a great idea. And as well, putting in these new forms like the rapid response mechanism in the USMCA, I think that's fantastic. Thank you. I think we didn't hear from Petros or Julian, if you wanted to.
I would just say one thing. The reason why I agree with Jennifer's previous point that the reason why teaching WTO cases makes sense is because of the influence they've had, not only in the WTO, of course, but in terms of precedent, but also in other free trade areas. What I try to do when I do WTO cases is I want to alert the students to build on what Jennifer, agreeing with her 100%, said. I want to alert students to the fact that you have a judge who's in a very, let's say, hard position, because a judge in the WTO faces two incomplete contracts. One is the WTO per se, and the other is the Vienna Convention on the Law of Treaties, which does not assign a coefficient of importance to the elements mentioned. And I try to show to students how the judge in the WTO, it's irrelevant if I agree or disagree, it's totally irrelevant, how the WTO judge addresses this relationship and what are the lessons to draw for other courts. Because the Vienna Convention, Jennifer said correctly, I mean, the WTO decisions have been replicated. So by definition, there is some de facto precedential value. Moreover, they all use Vienna Convention. So for two reasons, whatever we do in WTO is something which at least is food for thought for judges in other contexts.
That's great. This, I think, goes also to Julian's point about thinking of our class not necessarily as preparing people to become international trade lawyers per se, but we're preparing students to think through legal problems in a variety of areas. And this is just one brilliant example of how we can use these types of, as Petros says, incomplete contracts or international instruments in creative and interesting ways. Julian, I'll turn to you then if you wanted to add.
Yeah, I mean, I've given my pay into WTO case law already, so I guess I just want to emphasize one thing that Jennifer said with an anecdote. I mean, to me, the truly distinctive thing, lots of regimes have non-discrimination, right? National treatment is a non-discrimination discipline. Lots of regimes of law have non-discrimination in them. Some even have national treatment, like investment law. So there's an opportunity to teach non-discrimination here, but what makes it unique and complicated and hard is the encounter with the facts in these kinds of really interesting factual matrices that we have. And it's fun, but it's also what makes this trade law, right? It wouldn't be trade law if it was just non-discrimination. It's trade law because it's non-discrimination applied to this type of factual matrix. And it's the encounter with the facts that makes me feel every single time I teach this stuff that I'm learning something new, and that blows my mind every single time I teach. It's not, I know what national treatment jurisprudence says at this point. I know how Japan alcoholic beverages work. But when I think about the facts, and here's the anecdote. So it's not about national treatment, but I was starting to teach anti-dumping for the first time last year. Never taught remedies before, but started to realize I felt like I needed to. And we were lucky enough to have Jennifer on campus for giving a talk. And I asked Jennifer about some cases that that I should consider. And we talked about hot rolled steel. And Jennifer explained to me that hot rolled steel is a case where Japan was accused of dumping hot rolled steel into the United States because they were selling it for far below the costs, not exactly of production, but for what they were selling it for domestically. And Jennifer explained to me that the problem is if you understand how the production works, how the machines that roll the steel and hot rolled steel actually produce the steel, you learn that when you turn them on, it costs an enormous amount of money, but then you can just keep them going, keep them going, keep them going. So the price seems artificially low because they clear the domestic market and then send a bunch of this cheaper steel to the US, but that's because there's no incentive to turn it off. It's not nefarious. So if you can't understand how the law works without understanding these really difficult quirks in the facts, and sometimes they're not even there on the page in the case. So it's not just that it makes it more fun and exciting for the students. It's actually like, this is what the law is. This is how you litigate a case. This is how you win a case, is understanding the facts better than the other guy. So that was meaningful for me. I get to be the student again.
That's fantastic. My contract students are always so annoyed when I tell them that contract law always depends on the facts. The mantra of my contracts class is it depends. And they're always really frustrated by this. But I say, look, this is what commercial disputes are all about, right? And so I think this is such a generalizable principle beyond this field. Okay, the next question I'm going to ask you guys about is materials. So as I said in the intro, materials have always, I think, posed a challenge in this field because, not to echo the US, but, sometimes these, dispute settlement judgments are extremely long. They're difficult for us to understand. They're difficult for students. So how do you think about using materials in this field? Obviously, you're toggling between treaties, what we might kind of look like judgments, articles, opinion pieces, lots of different ways you could engage with materials. I know some folks in this room have been involved in designing casebooks, and those are casebooks you use in your own classes. So I just wanted to ask, what goes into the process of designing, choosing, supplementing teaching materials? How do you deal with the kind of particular challenges of these materials that are somewhat different from some other areas of law, or maybe just like other areas, but even more intense? There are length issues, complexity issues. And Julian, I had you down. You haven't gotten to start a conversation yet, so please, you work on one of these casebooks. Tell me about it.
Yeah, so I think 3 of the 4 of us actually are authors of a casebook. And one nice thing, I think, is that all 3 of our books have really different approaches. And so it's not a matter of like, oh, this one is the best one, and then there's ones that are mere simulacra. They're just totally different theories of how you approach a case. So I'll just tell you a little bit about what goes into mine. It's not going to be a great surprise that I think that reading cases and learning the facts is an important touchstone here. So this is the casebook I work on is together with Joseph Weiler, Sung-Jun Cho, and the previous edition was Isabel Feichner. And the new edition, we're going to have Kathleen Clausen joining the team, and we'll be dropping a new edition hopefully very soon, certainly in time for teaching it in the spring. It's mostly done.
Obviously.
Yeah, this is an advertisement. You can find it at a store near you for the price of $0. We make no money on it. It's a free online casebook and always has been. The reason, number one, that it's been a free online one, partially it's out of belief that it's good to have these things be available to everybody, but also no publisher would touch our book with a 10-foot pole. And that's because in order to get the extent of facts out there, we need to have really long excerpts of the cases. So this is the book that you use if you want to use very, 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 very long excerpts of the cases, which feeds into a certain style of teaching, right? You can't cover an enormous array of things with this class. You can't just assign 45 pages of Japan alcoholic beverages and expect to cover that in a class. It takes me 3 or 4 classes, 3 or 4 75-minute classes to get through that one case. And you ask the students to read it all up front, to buy in up front, and then you sort of tell them targeted in a targeted way. Here are the little bits and pieces we can reread as we go on. I'm happy to share my syllabus with anyone who wants to see how I do this. And I do this with every unit. General exceptions, I say, read this case and we're going to talk about it for 2 weeks, for 2 classes. Read turtle shrimp, we're going to talk about it for another 2 classes. The reason I do it that way is because I want to be able to dedicate a period of time at the beginning of every discussion, first, to a close analysis of the treaty text in question. Second, to an encounter between that treaty text and some facts, and make the students go through the process of analyzing the marketplace themselves. And then only at that point do we get into the case. And I want to have the opportunity not just to talk about what the appellate body said, but to navigate what the lawyers could have argued, how you could do a better job, what we think of what the appellate body ultimately said, why we think they ultimately said it, and feed that into the policy discussion. All those things take time. And so, in a sense, this is a book which has really long excerpts for the theory that less is more, and you're just not going to teach as much stuff. If you want to cover a lot of things, the other books will be better for doing that.
Mm-hmm. Thanks. Jennifer, did you want to chime in on this?
Sure. First of all, I want to just commend Julian and Joseph Weiler and everybody for what they do. And I would totally agree with him that if you want to teach, a limited number of cases and have students really understand them, that's the way to do it. Their textbook and their approach is absolutely the way to do it. I'm on a textbook, again, free online. So again, nobody's making any money here. Soon to be translated into Chinese and Spanish, which I'm very excited about. But it is meant to be if you will, it's at the polar opposite end. It is meant to be the cover the waterfront. If you only have a 2 or 3 credit course in trade and you want to make sure your students at least are conversant in all of the subjects of trade, it's got, a chapter on anti-dumping. What is anti-dumping? How does it work, etc. A chapter. But as a result, you cannot do what Julian has described. You cannot go into every real detail of any given case. It is much more in that sense trying to teach you kind of the black letter law of the broad swath of trade obligations, with enough assessment of there's a lot of cases here and some of them have ruled. And again, the issue, as you said right from the beginning, Joanna, is how do you put in enough facts that the findings make sense? Because to me, that is the hardest part of it. Because if students don't understand the facts, the rulings make no sense to them. They're just words on the page. So you have to bring a case home by having enough facts there that you can understand what was this dispute about? Why did the United States put turtle excluder device requirements on their shrimp nets? And why was this such a problem for developing countries, et cetera, et cetera? You have to have enough of that. And so for us doing this book, what we opted to do is basically summarize the facts ourselves rather than try to pull the excerpts out because they were very long. So we wrote the facts, if you will, which again has a bias to it. Which facts did you choose? Which ones didn't you? And then you sort of excerpt what the panel or the appellate body decided in this case. And it's nowhere near the kind of treatment that Julian is talking about. So it's just a matter of, kind of what do you want to teach and what do you want students to walk away from with, basic knowledge of across a wide array or much more in-depth and kind of legal skills in a narrower part, but, again, with a different depth of skill in the way that Julian teaches it. Neither is right or wrong. So I think they're just very different approaches. We've also tried to make sure that we're including, again, some of the narratives around trade, try to include, videos and podcasts and other things, that students might want from an online textbook, and also try to, put in those useful hyperlinks so that you can just immediately go right to GATT Article 1. Whenever you're talking about MFN, just click right here and it comes right up for you. So students can toggle between the text, the underlying text, and what you're talking about, very easily, very readily, to just make it, in that sense, user-friendly. As long as you're going to go to an online book, that was the hope behind it. But again, it's a very different approach, because ours is much more kind of skimming the surface, and again, intended to be, you can teach all of a particular subject in one class, one lesson, one set of readings, no more than 35 or 40 pages per subject. That's it. Completely different style.
Well, and the best part about them being free is we can mix and match, right? So I actually intend to use both of these in my own teaching. And I think that's just such a gift to have scholars who are so committed to bringing these different approaches into casebooks. So thank you. Petros, did you want to come in on this?
Nothing much.
Yeah.
Nothing much to add in this. I mean, there's not much I can add to that. I mean, it's the one thing I do is I rely less and less on I use Jackson Davis Sykes because it has a lot of the economics that I want to pass on to students. But the one thing I do on top of that is I'm in constant and consistent contact with Bill Davy and Alan Sykes, who are friends of mine forever, to see what new stuff they bring into the classes, and I say what new stuff, and between the three of us, we keep updating the sources that we use, because I use lots of sources additional to the casebook. There are so many writings nowadays, so I have to make a selection. I try to go for pieces which are like Peterson Institute type of pieces, let's say concise, 4 or 5 pages, so I can give 6 or 7 every week, and it's okay, it's digestible for students, because there's so many things happening, and it's impossible that you can put all of those things in the casebook.
That's wonderful. Chantal.
Yeah, well, so yeah, again, agree with what everyone has said. I don't have a casebook. Why would I when I'm spoiled for choice? And I think the open access model is just so commendable. It's so important, with all of the barriers to higher ed. Making these materials available online for free is just amazing. I think the only other thing I would add is that I will I supplement with a lot of my own materials. In addition to trying to do deep dives on at least a couple of important cases like Japan alcoholic beverages and shrimp turtle and so on, I also spend time with the sort of other areas of rulemaking in the WTO. Yep. Part of this is because I try to center questions of development, labor, human rights in thinking about the trading system, because from a law and society or legal realist standpoint, I'm working from social problems. And I think when you do that, you see some important areas where the issues haven't arisen necessarily in the dispute settlement system, and certainly development in the shrimp turtle cases Jennifer suggested. But for example, I spend at least a class on the Kimberley process, which exists in the WTO as a waiver, but then we look at the Kimberley process system for banning imports of so-called conflict diamonds. And that's it's not at the center of what we would think of as international trade law, because it's a waiver, it's adopted by the membership, not in the context of the dispute settlement system, but its success and failure, I think, says a lot, has a lot to teach us about how trade interacts with these other areas. Another example would be TRIPS and public health. So the decision on TRIPS and public health in the Doha round, again, it was more of a legislative decision, sort of taken in the context of the ministerial conference, not arising through the dispute settlement system, but I think also very important for understanding some of these other challenges. So I guess it's more of the the overview and then the deep dive, although we try to have some deep dives too. But there's so much, hopefully gives you a sense of all the great things that you can talk about and how to make, the subject really vibrant.
That's wonderful. Yeah, that broadening of the frame through those other, not just other legal types of questions and waivers and plurilateral agreements and the non-relationship to labor and labor. I mean, I think that's essential as well. So wonderful to hear about that. Thank you. We have very few minutes left. I had another question, and we've had a few questions in the Q&A. So what I think I'm going to do is just summarize those in a gloss and then let anyone react to anything I've said with a final statement. You can ignore what I've said and just say something else as well. So here are the kind of final issues I want to put on the table. So the final issue I was going to ask is how international trade law relates to other areas of law. Is do we need to be teaching investment? Do we need to be can you segregate it out? Is international economic law the better frame in which to be teaching these materials? We've talked extensively, or at least we've touched on the idea that history and politics and economics are important here when setting the scene. Can you do trade just as a legal area, or do other things need to come into it? And I think this goes to what a few people have asked about in the comments. So we've seen a question here about teaching non-trade issues, which I think goes to Sean, or non-trade, quote unquote, issues, like trade and issues, such as human rights, labor, child labor, and so on. How do you incorporate those? How does that relate to your conception of the field and its relation to other areas like human rights? And one commentator has also here asked us if we are doing more on security. And I think that goes similarly to the question of kind of what the core is and where are we changing the core of what counts as our field. So just any final comments there? We don't have that much time. And again, you can just ignore what I've asked if you prefer and wrap up on other things. And I leave it to you guys to just jump in here, or I can call on you if you prefer me to go down the line here. Maybe I'll do that. That's a little bit easier on Zoom. Julian, do you want to say you're the first person on my screen? So any final
Getting cold called. Brings me back. I'm going to say this, it's not to ignore what you said, but it's actually, I think they're directly an answer to what you said. I just want to leave with a call to keep teaching trade law and to keep teaching trade law as trade law. I mean, I write about international investment law more than I write about trade. And I teach international law. I think all of these things matter a lot. And I don't think arbitrary disciplinary boundaries are worth preserving. But trade law, it's like a 1L course in a sense. It has its own logic. It has its own rhythm that's extremely different from the more property-centric international investment law, which you could maybe put something like TRIPS closer to, but the rest of trade law is just really like that. It's different from international law in so many distinct ways. And it's of fundamental humanistic importance at this moment, right? This is a time when it's important that our students be able to see clearly through the insanity of the way that trade is talked about on the news every single day. And the only way you can get there is by learning what this thing is all about. So every day I sit around and think, like, am I just teaching Roman law right now? Is this like a dead discipline, the Old Testament? And the answer is just no. Right? It may be suffering a moment of crisis. It may be in a moment where the systems through which we adjudicate international trade law might not subsist in the way that we've had them for a long time. But to understand the basics right now is of such utmost real life political importance to all of our students. I wish more of them took it. And I really think it's important to keep this course contained for the purposes of not just, teaching the way I always teach, but for the purposes of, justifying what we should be doing with our time.
Thank you. Okay, Chantel, your final sentence or two, if you want to get in the mix here.
Yeah, we should, of course, continue to teach trade law. I've always understood it as intersecting with other areas of law, not for purposes of displacing the fundamental disciplines, but for understanding the both law in the books and law in action. So I'll continue to present it in that way, but I think it will go on one way or another to shape the debates that we have about what our economic regulation regime should look like.
Wonderful. Jennifer.
So I want to second what both have said, and especially second what Julian has said. So in addition to teaching trade, of late, I have also taught a course on international economic law and the institutions connected to it. So I'm touching on trade in the WTO, finance in the IMF, development in the World Bank, investment, ICSID, OECD, UNCTAD, etc. And again, I'm covering the broader swath of what I would call all of international economic law. And students occasionally ask me, if I'm interested in trade, will I get enough trade in your class? And my answer is unequivocally no. If you want to understand trade law, you need to take a class in trade law. And to me, the field of trade law is now even including, again, national security law. So you need to, again, that needs to come in. As you said, trade law now needs to include a lot about the intersection between labor and trade and human rights and trade and climate change and trade, because that is becoming a real intersection. Even if you look at what Trump has done on the tariffs, we all now need to understand rules of origin in a way that we never had to. It never used to matter whether a good was made in Malaysia or Indonesia or Vietnam, because the tariff was the same. And now we really do have to understand that, because guess what? It's no longer the same. So even a lot of the, again, so even the field of trade law within staying in our lane of trade law is a bigger field than it was even 10 years ago. So to me, even more reason why it needs its own dedicated course in trade law that does include these things that have in the past been at the periphery, which are no longer there. But in and of itself, it requires its own dedicated course, and it absolutely is one worth teaching.
That's wonderful. The idea that the breaking of the law is causing us to need to know more about the law. Wonderful. Petros, the final word for you.
In two sentences, Ricardo's comparative advantage is still good, makes sense. And economics has not been, it's one of the very few theorems have not been undone in over 200 years now. So as long as there is trade, because comparative advantage matters, there will be need for trade law. And on a personal note, the reason why I was doing antitrust, I was very happy with antitrust. And at Berkeley, this was my field. But I moved into trade when I went to Michigan. I owe a lot to Michigan. I spent 70% of my time in the economics department with Deerdorf, Saxon House, and Bob Stern, and 30% with John Jackson. The reason I moved to trade is because exactly what Jennifer said before. In antitrust, you care about efficiencies, and that's about it. In trade, you have to get into the policy interface, both horizontally across nations, but also vertically within a nation. Jennifer has had experience as an administrator in the US. She must have had to deal with the health guys, the treasury guys, these guys, that guy. This is something you will never have in antitrust. And that's the beauty, I think, of international trade.
Thank you. Thank you all so much. This has been so amazing. We could keep going for hours. And indeed, maybe we'll have to have a follow-up another time. This was wonderful. Thanks to everyone who came. This has been brilliant. I'm sorry we didn't get everyone's question answered, but hopefully we touched on some of them. A plug for our next event in the interest group on the 22nd of October at 9 a.m. We're going to have a roundtable discussion on contemporary issues in preferential trade agreements. So to follow up on a lot of what we were talking about here today, based on a new book from Kathleen Clausen, Manfred Elsig, and Rodrigo Polanco. We're also going to have Deborah Elms and Just Paulin in that conversation as well. So this is to be continued. Thank you all so much. Such a pleasure. And I look forward to seeing you all soon in